Ladies and gentlemen, welcome to the Weekend Case Review featuring Judge Cedric Simpson this Saturday, all Saturday long. We got a whole lot of cases coming up for you. We got about 2.5 hours worth of Simpson coming up. We're going to start off with an actual preliminary hearing, which features some interesting evidence. Ladies and gentlemen, what I'm trying to get to here is you're actually going to get to see a fight that takes place, and it's an interesting case that pans out. After that, we got a whole lot of people coming in front of Cedric, and this all takes place on Monday and Tuesday of last week. So, ladies and gentlemen, thank you for showing up. The show's getting started, and we're going to get right into it.
Court does call the case. People versus Bahar Kasham.
David I. Goldstein appearing on behalf of the defendant.
Take time set for trial. Are we ready to proceed?
We are, Your Honor. There's one thing I want to talk to Mr. Goldstein about, but I just need 1 second, please.
Sure.
Let me step up for just a second.
Oh, you're leaving.
I'll be right back.
No, it's okay. Nobody said they were leaving. Why bother? They're gone. No, thank you, Al.
Recording in progress.
What were we not doing? It was not you.
It was up, Your Honor.
Okay, we're on the Kasham matter. Are we now ready to?
Yes, Your Honor.
Yeah, ready, Your Honor.
All right. Opening statements.
Yeah, Your Honor, would waive opening if there's no objection from the defense.
No objection. I'll waive also, Your Honor.
All right, very good. You may call your first witness.
Bernard Kilgore. Your Honor, for the record, Washington County Internet is experiencing intermittent outages this morning, so if there's some delay in presentation of exhibits, I do apologize.
Mine's working just fine. Anyway.
I'm very glad to hear that, Your Honor.
All right. Exit now.
We take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth, so help you God. See, state, spell your first and last name for the record, please.
I'm Bernard Kilgore, B-E-R-N-A-R-D-K-I-L-G-O-R-E.
Thank you. You may proceed.
Thank you, Your Honor. Good morning, sir. How are you employed?
I work for Instacart.
And what capacity do you work for Instacart?
Full time.
And what do you do for Instacart?
I'm a delivery driver.
Are you a shopper as well? Where are some of the stores that you shop?
All the major stores. I do Myers, Kroger, Target, Sam's Club, Costco, Total Wine.
Were you shopping on April 3rd, 2024?
Yeah.
What was one of the stores that you shopped at that day? Where is Sam's Club located?
It's in Michigan.
Is that in Washtenaw County, state of Michigan?
The court will take judicial notice that Sam's Club is located in Pittsfield Township.
Is that the location on Carpenter Road near Michigan Ave?
Yes.
What time about were you there, if you recall?
Afternoon.
What happened when you got to Sam's Club to shop that day?
I picked up an order for a customer. Order came to my phone. And as I walked into Sam's Club, there's two ways you can get in You want me to tell you the whole thing?
Please.
Okay, so there's two ways you get into or get to the part of Sam's Club where I go to get my boxes, which is back in the produce. You can either walk towards the front, past the people that ask you if you want to change your phone service, like T-Mobile, whatever, or you can bypass them and go around the back towards the produce and it ends you up where the box is at where I need.
Which way did you decide to go that day?
I always decide to go towards the back to bypass the people in the front. I'm talking to me because I'm actually working. I don't have time to slow down.
So when you talk about going around the back, like what section do you sort of loop around to get to where you like to walk?
So in the Sam's Club, the first rows, I go to the back, past the automotive, pet stuff, baby stuff. And at the end of that row is the produce section of Sam's Club.
Okay. What happened as you
You
were
take
headed?
the first row and you walk all the way down past like the eye center and like all the way down.
Yeah, so
On
go
that
past
back
the
side.
That way.
Gotcha.
Yeah.
Okay.
What were you doing while you were walking toward the produce section where the boxes are?
So I was looking in my phone. I'm always in my phone while I'm working, looking at the customer's item list. So I was in my phone looking at the list to see how many boxes I would need to pack their order in.
What happened?
As I'm walking with my cart and looking at my phone, I'm hearing, is that Trip?
Is that Trip?
Yeah, that's my middle name. Trip is my middle name. Trip is the name that I go by. I don't go by Bernard. Everybody who knows me call me Trip. Middle name.
TRIPP?
Yes.
What happened when you heard that?
So I heard, is that Trip? And I'm still in my phone, but I'm not really paying attention to it slowly. And then when I look up, I see him and his daughter rushing at me and him saying, remember I told you I got something for you? When
All
I
right.
see you
Let's pause there. Who's him?
on her.
Mahar Kasham?
Yes,
Do you see the person you know as Mahar Kasham in the courtroom?
yes, right there in the white lady.
Your Honor, may the record reflect and was identified the defendant.
Record shows so reflect that objection.
So you said you saw him and his daughter?
Yeah,
Had you seen his daughter before?
no.
And what happened after you saw the defendant and his daughter?
They was rushing up to me attacking me.
What happened next?
While they was attacking me.
How did they attack you?
So before I put my phone down to defend myself, my heart was swinging on me and his daughter was swinging on me on the videos.
What happened while they were swinging on you?
My heart was punching me and his daughter was punching me, trying to punch me too, but while I was trying to keep my heart off me, his daughter reached up under and grabbed my shirt, broke my chain off. But I wasn't trying to, I guess, punch her. She's a girl at the end of the day. I was just mushing her back, but while my heart was still swinging.
What happened after well, I guess let me ask you a different question. What happened as this was going on? Did you stay in the same location in the store?
No, so while they both were trying to attack me or jump me, they pushed me back into a emergency exit door, which sounded the alarm and that's what notified the workers, and I guess the police would come.
Are you familiar with where this emergency exit door is within Sam's Club?
Yes.
What happened after you went through the emergency exit door?
After I went through the emergency exit door, I pushed my way back inside the Sam's Club, and then I remember I was drugged to the floor, and they were still fighting.
And while this was going on, you were still physically engaged with each other, still fighting?
Yes, and I had pulled my coat over my head, so I really couldn't see when they drugged me to the floor. I don't know if it was him or his daughter that was kicking me in the back of my head.
But Mahar, was he making physical contact with you, punching, hitting, kicking something up the whole time? Now, you mentioned that there was a video. Have you had a chance to review the video this morning?
Yes.
And Your Honor, for the record, the parties did stipulate to the admission of this video. Mr. Goldstein and I have looked at it. I'm going to start it at about the 13-minute, 45-second for this clip. If the court will allow, I don't think there's any objection to starting there. Mr. Kilgore, can you let us know when we can see you in this video?
Your Honor, I'm going to object. My
Okay, stop.
My understanding is that the law recently has been that when videos are put as part of a court proceeding, the videos are the evidence. And it's not proper to narrate what's seen on the video. Now, I know that usually comes up in the context of police videos, dash cams and so forth, and the police then saying this is what happened. And the appellate courts have said, no, the video speaks for itself. So
Well, I get what you're indicating, and I do think it applies in a different context. I think the only question that was asked is where he is on the video.
Your Honor, what I was about to say was that if that's all she's going to ask him, that's fine. I'll withdraw my objection. But if she's going to ask him to narrate what's being shown, then I'm going to object.
Understood. Okay, go ahead.
May he answer the question, Your Honor?
Yes, he may.
Can you see yourself on this video at this point? I've paused it at 13:59.
Yes,
Where are you?
with the basket in the middle of the aisle,
What are you wearing?
jacket
Okay.
and hoodie under it.
And Your Honor, oh, thank you. My only other intention is to ask if he sees the defendant on the video at some point. I don't intend to ask him to narrate what's happening in the video.
Understood. Okay. I'll allow that question.
Thank you, Your Honor.
Go ahead.
And for the record, I'm going to stop it at about the 18-minute and 15-second mark of the video. Excuse me. Did you have any injuries as a result of this incident?
Yes.
What injuries did you have?
From kicking the head, headache, nose wrapped up.
Was your clothing damaged?
Yes.
How?
Blood on.
Just have one moment, Your Honor.
You may.
Thank you. I'll pass the witness, Your Honor.
Cross-examination.
I have no questions. Your Honor.
All right, no questions. You may step down.
Your Honor, this witness be excused.
Any objection?
Sorry, Your Honor.
Any objection to the excusing of this witness?
No.
No, this witness may be excused.
Jake Millar for the.
All right. Come forward, be sworn.
See you raise your right hand. Solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. See, state spell your first and last name for the record, please.
Jake Millar, Jake, time out Y, M-A-R.
You may inquire.
How are you employed, sir? How long have you been in that position?
1 year as a clever.
Were you so employed on April the 3rd, 2024?
Yes, ma'am.
Were you working that day? What were you wearing?
Pretty much the exact same thing.
Class B uniform?
Yes, ma'am.
Displaying your badge of office?
Yes, ma'am.
What were you driving?
Fully marked.
Were you dispatched to the Sam's Club located on Carpenter Road near Michigan Avenue? I think the exact address is 5450 Carpenter Road. Did you make contact with anybody in the courtroom on that date?
So they,
Did you make contact with anybody who's currently in the courtroom on that date?
yes, ma'am.
Was one of those people the defendant?
Yes, ma'am.
Who do you know him to be?
This is Mark Shum, the gentleman with beer.
Your Honor, may the record reflect that this witness identified the defendant.
Without objection, record shall so reflect.
When you made contact with him, what did you notice about his appearance?
He appeared that he was in a physical altercation. His clothing was distressed as if he had been fighting with somebody. I also observed abrasions on his knuckles. He had blood on his clothing.
Did you ask him about the source of the blood?
Yes, he said that came from the victim that he was fighting with.
Did you ask him about, what did you say about his knuckles? I'm sorry, I didn't hear
He
you.
had abrasions on his knuckles. He had been punching something.
Did you ask him what happened?
Yes, he said that.
What did he say happened specifically in the order of events?
He said that he had recognized Mr. Kilgore, called out to him. Then Mr. Kilgore that took off his jacket and approached him with his fist closed. Then Mr. Kilgore slurs against him, threatening his daughter, that punched each other at the same time, that mutual combat. He said that at some point they ended up on the ground as well, but the altercation was essentially.
I'll pass the witness.
Questions, Your Honor.
Thank you, officer. Appreciate it. I guess happy anniversary.
Yeah.
Any additional witnesses for
No, Your
the,
Honor, full request.
At this time, Your Honor, I have a motion for a directed verdict. I guess if this was a jury trial, it'd be a directed verdict of not guilty. We have testimony of Mr. Kilgore that he tried to portray it as basically he was minding his own business and he got attacked. The officer testified that when he spoke to my client gave a different version. The interesting thing about my client's version is it's supported by the video that the court saw. The court saw Mr. Kilgore leave his cart, turn around, and approach the defendant. So at best, it was mutual combat. At worst, it was an assault by Mr. Kilgore on my client. And my client at that point was with other people. And so his swinging on Mr. Kilgore in response to Mr. Kilgore's action was appropriate, given that he felt he had to protect the two females that were with him. This was not an assault by my client. The video supports that. The video also supports that Mr. Kilgore's version is not true. That video very clearly shows Mr. Kilgore walking toward my client in an aggressive manner. So we're asking the court to find my client.
You're claiming at the point he passes that aisle, he turns around and goes back towards your client. You're not claiming, I just want to be clear, you're not claiming as he's coming down the back aisleway.
No, you can see him push the cart, turn around, and walk back toward my client.
All right, I may have to look at that again, but go ahead.
I was actually going to play the video that was admitted, Your Honor, as part of and then give my response sort of along with the video. It may be just a few seconds before it originally started, but I don't think it'll be as.
While she's doing that, let me just continue. He talked about being on the ground and being kicked in the head. That doesn't show anywhere on the video. It also shows that after the initial contact between them, Mr. Kilgore continues to approach my client. Now, at that point, I will concede they're both approaching each other. I mean, as they say on the street these days, game on. But at that point, it certainly, Mr. Kilgore was not a passive victim in this particular case.
And Your Honor, in response to that, I will first play the video and then I will make my arguments.
All right.
I think we're just a few seconds before when it originally was played, but
Go ahead.
not a substantive amount.
Go ahead.
And Your Honor, with the court's permission, I'm going to go back and just play the very beginning of it, because this is where my argument really begins. Mr. Goldstein says that the defendant was approached by the victim, and Officer Malarnek, he testified that the defendant told him that the victim took his jacket off and then swung at him. That's clearly not what's demonstrated on this video. The defendant is the first one to begin the physical contact. He's the first one to throw a punch. And we'd ask that the court deny the directed verdict motion and allow this to continue to let the court render its verdict in the matter at hand.
Your Honor, in my argument, I never.
Back up just a second.
Yes, sir.
Just Lonnie. Okay, right there.
Will that work?
Yes.
Okay. If I don't. But he is.
Your Honor, in my argument, I never mentioned who swung first. What I pointed out was that the testimony of Mr. Kilgore was that he was basically minding his own business and the defendant rushed at him. This video shows that he was approaching the defendant. Actually, they were approaching each other. I didn't talk about who swung first. What I talked about was that Mr. Kilgore was acting in an aggressive manner.
That's correct. But what I'm saying is that the defendant told the police Mr. Kilgore swung first, but that's not what's shown on the video. I'm nothing further as to the directed verdict. I'm happy to answer any other questions the court has.
All right. The court, in looking at the exhibit, and addressing this as a directed verdict, taking into the light most favorable to the non-moving party, that being the people of the state of Michigan, the court would at this time deny the defendant's motion for a directed verdict. One can maybe make something of that, but I don't think that, given what I see at that point, that it would be proper for this court to rule on a directed verdict and dismiss this matter as a matter of fact. And so I would find that there would be sufficient evidence, potentially, that a reasonable fact finder could conclude, doesn't mean that they would, that the defendant would be guilty of this charge. So I'll deny the motion for a directed verdict.
This time we called the defendant.
All right. Sir, please come forward and be sworn.
Steve, raise your right hand. You solemnly swear to affirm the testimony about the guilty, the truth, the whole truth, and nothing but the truth, so help you God. So, have a seat. State and spell your first and last name for the record, please.
Mahar Kashan, MAHARKASHAN.
All right, you may inquire.
Sir, we saw a video, correct?
Yes, sir.
Did you hear any voices on that video? Okay, you were there.
Yes, sir.
Okay, would you tell us what Mr. Kilgore was saying to you as he approached you in that video?
He said,
Object to hearsay.
It's not being admitted for the truth of the matter, Your Honor.
State of mind.
State of mind.
I will overrule the objection.
so we had a conflict, so you know what?
No, just answer my question. What was he saying to you?
I was a bitch and I was gonna do nothing about it.
Okay, did he make any reference to you as far as your background was concerned?
Yes, during the fight, he called me a dirty Arab. Like 2 or 3 times.
I take it the two of you knew each other before this date?
Yes, sir.
Would you say there was bad blood between the two of you?
Yes, sir.
Okay, him toward you as well as you toward him.
Yes, sir. He threatened my kids.
He what?
He made a threat to my kids on the door. He wrote on the door. I had to.
On the door to what?
On one of my properties.
Okay. All right. Go ahead.
Just so the court understands, he was a tenant of yours, is that correct?
Yes.
Nothing further, Your Honor.
Mr. Kashan,
What, before you go on,
I'm sorry.
what happened with that tenancy?
Forfeiture. It was a land contract. Forfeit because he was in expense.
How long ago did that occur?
A couple years ago. A couple years ago.
Was there a court proceeding regarding that forfeiture?
Yes, Your Honor.
Go ahead.
That court proceeding is still ongoing, correct?
No.
When did it end?
And then, like a year or two ago, that was a lot ago.
So you said that, as to your state of mind, the defendant called you a bitch?
Well, because I said.
No, my question is very simple. You testified a few minutes
yeah,
ago. He called you a bitch. That was at Sam's Club?
That was in the beginning of the fight, yes.
Okay.
That was like right before it started. I told him, I was like, I was like, is that a trip? As soon as he turned around, he was like, I was like, oh, didn't you write that stuff on the door, mama?
Okay, slow down, sir. My question is very simple. My question is, he called you a bitch
Yes, ma'am.
at Sam's Club, correct?
Yes, ma'am.
Okay. And that made you upset, right?
Yeah.
And then he said you wasn't gonna do nothing, right?
He was intimidating me.
Yeah. It's just, my question is very simple, sir. It's just, is that what you said he said? Okay, so that's a yes?
Yes.
And that made you mad?
Just answered the question. Thank you. Go ahead.
Sorry, Your Honor, didn't mean to interrupt you. And that upset you, correct? It made you angry? Angry enough to engage in this physical altercation?
Take my daughter, yes.
That wasn't my question. Would it make you angry enough to engage in this physical altercation?
Sustained.
So you were there with your daughter and another woman, correct? And during the fight is when he called you that racial slur? Nothing further.
Nothing further. I'm sorry. Mr. Kasham, the verbal back and forth that Ms. Blondie asked you about, was that right at the beginning of the fight?
It was at the beginning of the fight, it was during the middle of the fight, and it was.
But it started at the beginning of the
Yes,
fight.
absolutely.
Nothing further, Your Honor.
Leading up to the forfeiture action on the land contract, were there altercations between the two of you before that?
Yes, sir.
Were there altercations during the forfeiture action?
No, not at all. I actually gave him extra day to, he said he wasn't ready, so he asked me if he could have extra day, and I told him absolutely.
Mr. Kasham, you have to keep your voice up so Ms. Blondie and I don't hear.
He needed an extra day to clean up, and I didn't want to put stuff out on the street, so he get an extra day, so he got to go out. I was trying to use.
Did that work out where he got his stuff out?
Yes, sir.
Okay. The door you talked about where things were written, where was that door located?
I was located right on the other side of his unit.
On Spinnaker Way?
Yes, sir.
So it was on the other side of his unit?
Yes, sir.
Who was in that unit on the other side?
It was empty at the time, but it was a Hispanic family who just left.
If you know, and I don't really necessarily want to speculate, why were there things written about your daughter?
They were intimidating. He was intimidating me. They were slashing our tires. They came in.
Hold on. I don't know who they are.
Well, it was him, and you could hear his partner on the phone. I Sam's Club on the speaker.
Not asking that. There, you said at a point there was something that was put on the door at this off of Spinnaker Way, right?
Sir.
What was his relationship to your daughter?
He didn't have any relationship to my daughter. He just knows that that's my heart. So each other.
So what do you believe would have provoked him to do that about you? You're the forfeiture. So when did that occur?
I don't know the exact date, but it was
But it was in the earlier part of 2023. Would that be fair to say?
it may be 2023, or it could have been 2022 also. At the end of 2022.
There are two people that are with you on that date at Sam's Club. I think it was two women. Who were they?
That was my daughter and my friend.
The one that was, I guess I'll just put it, engaging in what was going on, was that your daughter?
Yes, sir.
Down here. Oh, it is. Because it's vinegar. Got it. Okay. Had the two of you ever fought before?
I almost got into an altercation at a different eviction.
What do you mean at a different eviction?
I was evicting Ishmael Diallo also. And the Washington County was there.
All right. Was Mr. Kilgore there?
Yes.
Why would Mr. Kilgore have been there?
He was watching he's watching the possession of vicious stuff that I was putting onto the curb.
So you're evicting another unit,
Yes, sir.
and does Mr. Kilgore live in that area? Was this all on Spinnaker Way?
No, this was at Roundtree. His eviction was at Spinner Cove. The incident I'm talking about was at Roundtree.
Why was Mr. Kilgore there?
I think that was I believe that was his friend. He was just watching his property that was set to the curb.
Got it. Okay.
We're sending stuff out to the curb.
Well, and why on that occasion would the two of you have entered into a altercation?
As I was setting Ish's property onto the curb, I got out the car and he was flicking me off in this car. So I was flicking him
When
off.
did that occur?
That was, I think that was earlier this year. I believe that was earlier this year, sir.
So it would have been after the forfeiture of the land contract.
Yes, sir.
Okay. Any questions based upon the court's questions?
I'll let Mr. Goldstein go first.
I have no questions, Your Honor.
Just so that the parties are aware, I did pull the court record. There was indeed a land contract forfeiture out of 14B that was initiated on February 27th of 2023 when it was filed, and a judgment by default was entered March 24th of 2023 with a 90-day redemption period. And then after, or right at that 90-day, there was an order of eviction filed in June. Not entirely laid out, but the order of eviction was recalled on July 25th, 2023. As the writ was canceled after posting, which would fit into what Mr. Kasham said regarding a voluntary round.
I have one follow-up question. I'm sorry, Eric, that's okay.
Go ahead.
How old is your daughter, or how old was she on stage?
13.
That's all the follow-up I have. Thank you, Your Honor.
So at the time in 2023, she was what, 12?
No, she was 13 at the time, sir.
She was 13. At the time of this incident, she was 13?
Yes, sir.
I think that was the question you asked.
At Sam's Club, this assault.
She was 13. Okay. At the time of the forfeiture, she would have been 12. Is that right? If I have my dates right. In 2023, she was 12. Would that be fair? Okay. Well, I almost hate to ask, but I'm going to ask anyway. What kinds of things were written about your daughter?
They were gonna kill my kids and my brother's kids. It should be in the wash now.
They, who?
Uh,
Who is they?
Trip in his accomplice.
Yeah,
I had a trail camera set up and he barely I got the side of his face, but when the sheriffs came over there, they said they couldn't do nothing with it because it didn't really show, but I know who he is. You know, he did it.
I didn't ask all that.
I'm sorry.
Only answer the questions. You have a bad problem with that.
I'm sorry.
Any other questions based upon the court's questions?
No, Your Honor.
All right, you may step down. Any additional witnesses for the defense?
No, Your Honor. We rest.
Any rebuttal witnesses for the people?
No, Your Honor.
All right. Closing arguments.
And the people are asking the court enter a conviction of the assault and battery against the defendant. We've shown here today that the date and time of question, the location, the venue's not an issue, date's not an issue. None of those things are a question. It really comes down to this physical altercation. And the people have presented a video which really documents the happenings and comports with the victim's testimony. None of this happens unless and until the defendant calls out to the victim. That's what starts all of this.
Well, is that how do we know that?
The victim's testimony,
All right.
as well as the defendant said, I believe, to the police officer testified that the defendant told him he recognized Kilgore and called out to him. So that's consistent from both of them. But then that's where the stories diverge, and the video really provides a lot of instruction here. The defendant tells the police officer that the victim took off his jacket and swung at him, but that's not what happened. We can see in the video, there's clearly the defendant is grabbing the victim by the jacket, pulling the jacket over his head as this physical altercation continues. Your Honor, the defendant testified that he was angry.
Can I ask a question? Though?
Yes.
Let's say that there was a calling out. What do I do, or what would the people have me do with the fact that Mr. Kilgore stops, turns, and comes back toward the aisle that Mr. Kasham had just gone down going the other way?
Mr. Kilgore had heard his name that he goes by be called out. Somebody goes, is that Tripp? He turns and he looks and he goes back to see who's calling out to him and sees it's the defendant coming at him, Your Honor.
Before then, and again, before Mr. Kasham swings, why doesn't he keep walking?
I think
He's
it's
heading, by his own testimony, but also in looking at the video, he is headed down. He has basically one more aisle to go before he's back in the produce area that Mr. Kasham had just come from. Why doesn't he keep walking?
I don't know why he doesn't keep walking, except that somebody calls out the name that he goes by and he turns and looks. It's a very quick happening before the defendant and him are face to face and the physical altercation begins. Your Honor, that's really the meat, I think, of this. And I think that the video is the best evidence for the court. And I'm happy to play just that small portion again so the court can see it. And then we see this physical altercation happened in the way that the victim did describe it. It continues, it goes out, they go out the exit door, which you can see the sunlight kind of stream in from the outside when you're watching the video. And you see this altercation continue where it initially starts out the exit door, back in the other aisle where we can't quite see because it's the other aisle that goes the other way. It's blocked by the merchandise that's stacked up. And there's nothing to say that calling someone, saying, I have something for you, or calling someone a bitch, or saying you're not going to do anything about it. That's not where the assault and the battery begins. Where the battery begins is the altercation, is the physical fight. And I'm just going to play that last portion, and I'll reserve any further argument for rebuttal.
All right, go ahead. Can you back that up again?
Absolutely, Your Honor.
I have a question regarding it.
Sorry, I think I backed up a tiny bit too far. There we go.
Would you agree in looking at that it's, as Mr. Kasham is coming out of that aisle, that it's in fact Mr. Kilgore who is approaching Mr. Kasham?
I would agree that they were approaching each other.
Very briefly, Your Honor, because I think the tape, if it wasn't for the video, we'd be having long arguments, but the tape, I think, makes it much simpler. The so-called calling out was him simply saying, hey, is that true? Wasn't threatening, wasn't intimidating, wasn't in any way, trying to provoke him. It was just simply saying, isn't that true? And as the court, next point, as the court pointed out, they were coming to, I agree with Ms. Blondie, and I think she would agree that she and I agree much more often than I do with most other prosecutors. They were approaching each other, but you saw Mr. Kilgore swinging almost immediately with what in the old days you and I would have called a roundhouse right. He came from down low and swung with a wild right hand. And I can't tell whether he made contact or not, but he had a number of opportunities to walk away. And a number of times he came back and continued the confrontation. That's number 3. Number 4, you also saw in the video a number of times when my client interposed himself between Mr. Kilgore and the females and tried to hold them back, indicating that he was concerned for their safety. I think for all, now, you know what, Your Honor? I would be very happy if the court could find both of these parties guilty of something. But because the people chose not to charge Mr. Kilgore, you can't do that. So the next fairest option is to find neither of them guilty.
What I'll go to in rebuttal is this. I would ask the court, I'm going to pull up the exhibit again, the video, for the, 5th time at least, and look at, as the defendant is walking, he appears to be having his phone, I'm sorry, the victim is walking, excuse me, we see the defendant has already gone in the other aisle. Defendant is in the other aisle, victim is walking, appears he has his phone in his hand, his right hand, walking. We can see in front of his lighter jeans, looks like there's something black in his hand. Holding onto the cart with the phone, puts the phone down.
So right there.
Yeah.
Ms. Lundy,
Yes.
back that up and play as Mr. Kasham comes out of that aisle and focusing on what Mr. Kilgore is doing. It's clear what one can see what Mr. Kasham is doing. Right, why does he make those steps that he makes toward Mr. Kasham? If you could play that again.
Yes.
And that's probably the most troublesome part for the court. This isn't a circumstance where if we watch this, he comes out and then he's coming at him also. I mean, regardless of them both acting like absolute juveniles and they both need to grow the heck up, would you agree that at that moment, they're really just headed at each other?
I think they're walking towards each other. I don't think.
Play that again, because his steps are something different than just a walk toward Mr. Kasham. As Mr. Kasham's coming toward him. Then they both, at that one moment, and actually you can see probably Mr. Kasham's legs a little bit clearer. They're both bracing to swing. Look, it's just Mr. Kasham beats him. I mean, if I see it that way, what would the people's argument be?
The argument of the people is that Mr. Kasham is the one who begins the confrontation, calls out to the defendant, walks completely out of the aisle that he's in, walks down the other side. I'm going to call it the side aisle, like the outside aisle, for lack of a better term, goes towards the defendant. I'm sorry, the defendant goes towards the victim. The victim turns around to go towards the defendant, and the defendant
hold
swings
on, though,
first.
Ms. Lundy. When they get into that aisle, they're both headed at each other, aren't they?
They're walking towards each other, yes.
Right. And if you look at the posture, and if you want to play it again, you look at the posture of their legs. When Mr. Kasham comes out and as they get close to each other, Mr. Kilgore's hand drops. His posturing of his legs actually are very similar initially to that of Mr. Kasham's legs. They're going to swing on each other. There is not a doubt in my mind that they're going to swing on each other. And why does Mr. Kilgore, I guess I'd ask the people, why does he speed up toward Mr. Kasham? He sees him.
Yes. He has seen him at that point. I know what the court's talking about in the video where he's turned.
Yes. And then he sees Mr. Kasham. Mr. Kasham is walking into that aisle. He heads back. And if you play that again, and particular focus on the legs of both Mr. Kasham and Mr. Kilgore. They're coming out, and then do you see what I'm talking about in terms of Mr. Kilgore's legs? Mr. Kilgore kicks what would be his right leg back to brace to swing because he's coming from the right-hand side. I'm not an expert boxer, but I mean, I know how you got to brace yourself if you're going to swing.
I understand what the court is looking at for the legs.
Right.
But
hold on. I'm sorry. I don't mean to interrupt you.
No. I thought I was trying to answer the question, but I understand there's another question.
His leg comes back, his hand drops. And I would guess I would ask the people, especially given what has been said about the past between these two, why wouldn't this just be a circumstance where two people are coming at each other? The one that is more efficient in their swing is the one that gets charged. Because what's clear to me is that if Mr. Kasham doesn't swing, but given how he testifies, I don't think he has that discipline in him. But if he doesn't swing, Mr. Kilgore swings on him.
May I answer?
Yeah,
Thank
go
you.
ahead.
So what I'd like to show the court is as we go through these sort of second by second, and we see Mr. Kilgore has turned his head,
Right.
stops the cart, turns his body. Now we see Mr. Kasham is sort of at the end of the aisle coming
Right.
out. We see Mr. Kasham is approaching. Mr. Kilgore turns his body more and starts to head that way. And as we come together, we now see Mr. Kasham lowering his, what it looks like lowering his left half to the people and swinging that right hand over top. And
But
then we
hold
see
on.
Mr.
But
Kilgore.
as you're
I
stopped
know.
right there, look at Mr. Kilgore's leg.
Correct. He has now assumed that stance, but he doesn't have it until that hand goes up, is the people's contention. It's a
Until
different
which hand goes up?
Mr. Kasham's. So Mr. Kilgore is now walking,
But that,
and now he gets hit, and his legs have sort of gone to that stance. That would
he
be
doesn't
the,
quite get hit.
that would be what the people's contention would be regarding
Okay.
the legs there. Your Honor, the people believe the evidence shows the defendant swung first, and we're asking the court to return a verdict of guilty. That's all I have in rebuttal. Thank you.
Thank you. You're off. Let me get, court's gonna take a brief break before I make a decision on this, but I've gotta do one thing. Detective Erskine, are you there?
All right.
What do you think, guys? You're about to find out what the ruling is. Does it matter who swung first? Let's find out.
The 14A District Court for County of Washington, State of Michigan is now back in session. Jay said Simpson presiding.
You may be seated. Back on the record in the case of the people of the state of Michigan versus Kasham. In this matter, the court has gone through this and reviewed a few cases, particularly regarding that of mutual combat, and it can sometimes be a, I won't say a discretionary call, but there's that issue. And while it's not entirely applicable, the notion of one being in an area and allowed to stay in that area and defend themselves from an attack, all of those things came to mind as it regarded this case. But the video in this court's mind speaks for itself, when particularly when closely examined. Mr. Kilgore's arm, his right hand, well, let me back up, because if I take the testimony that Tripp is called out, he begins to walk back. He turns and walks back. There's not a doubt, no question about that. At that point, however, Mr. Kasham is coming out of the aisle. There is a point at which the two are still distanced from each other, and clearly Mr. Kilgore can see who it is. If that were his sole reasoning for his sort of curiosity in turning around. And if it were to stop there, likely we wouldn't have had an altercation, or if Mr. Kasham had continued to advance with Mr. Kilgore doing nothing, it would be a much clearer case of an assault and battery. However, that's not what happens. What happens is that the two of them begin to close on each other. Part of the reason that we're here is because, as oftentimes this court finds itself in, is that the individual who may end up getting charged is indeed the individual whoever landed the first blow. That's what happened in this case. Mr. Kasham lands the first blow. Part of the reason that he lands the first blow, however, is because as they're closing, and while the court was looking at it and while the prosecutor was up, Mr. Kilgore's feet are not in a position for him to swing with his right hand. His right hand is clearly down in position to come around, but his feet aren't. But if you watch just the next split second, after being hit, he tries to shift his feet to make that swing. I don't know that I can think of a case where two people are coming at each other. I believe that both are at some point aggressors in coming at each other, and that this court's mind by definition makes this a mutual combat situation. Now, having said that, there then becomes other points in time, Mr. Kasham being the one on trial, where the court could have focused in on his actions then constituting assault and battery because he comes at Mr. Kilgore. Court won't do that. That wasn't the focus of this trial. I'm not going to do that because, and I almost hate saying Mr. Goldstein would be corrected and that both would be charged, because at the point at which Mr. Kasham at some point is coming after Mr. Kilgore, there is a corresponding point, quite frankly, that Mr. Kilgore then attempts to try to go after Mr. Kasham. If I had my druthers, I would find you both guilty, because and that's what I would do, because I think you acted like two high school kids trying to resolve something that as grown adults, you should find a better way to do it. But I am left in this circumstance with that focal point. It wasn't an assault in this, it was a mutual assault, if one wants to call it, but they're closing on each other. They're trying to both advance and come to blows with each other. It's just that Mr. Kasham was in the better position regarding his swing to take the swing. He hit Mr. Kilgore. And again, that's why I think we're here. So for those reasons, the court does not believe that the people have sustained their burden. Well, the people haven't sustained their burden that the defendant is guilty of assault and battery. The people, I think, have shown that there was one without taking into account the actions of Mr. Kilgore. But the court, I think, won't think it's left with any alternative but to find the defendant not guilty of these offenses. Defendant's found not guilty.
Thank you.
Your Honor, I'll try in the future not to put you in a position of having to agree with me, okay?
Please. It's hurtful to me as a human being. It's hurtful. And, pardon?
I think staggered leaving might be able.
Yeah, Mr. Kasham,
Sir? Yes, Your Honor.
you have a seat until Mr. Kilgore is out of the building. You can have a seat back there. Don't sit at my table.
Thank you, Your Honor.
Just don't leave until such time as we say you can leave. And also, you have that for Detective Erskine.
Yes,
Right,
sir.
okay, thank you.
It's okay if you want, you know, make sure you don't.
Oh, okay, thank you, officer.
All right, guys, that's over, and we're going to move into the rest of the day. This is still going to be a good bit of Monday. We're going to see a few probable cause hearings, because I just like the cattle call, and nobody does it quite like Simpson. Let's keep going. After this cattle call on Monday, we're going to be moving into a little bit of a cattle call from Tuesday that was very interesting, and some really interesting Tuesday hearings.
Thank you.
All eyes. 14A District Court from County of Washington, State of Michigan is now back in session. The Honorable Mr. J. Simpson.
You may be seated. Yeah. Okay. Court does call the case, People versus Ryan Atkins.
Good afternoon, Assistant Public Defender Lauren Parent, on behalf of Mr. Atkins. Mr. Atkins, please state your name for the record.
Ryan Atkins. Oh, thank you. I don't have the public, I don't have the prosecutor here. I'm good. Okay. Thanks, so, yeah, appreciate it. Never mind, we were having a personal discussion.
No problem. Your Honor, today is the date and time set for sentencing. We did review the pre-sentence report. We have no material additions, deletions, or edits. I would like to address the recommendation. I did review it with Mr. Atkins. He is asking, frankly, for credit for time served, sentence, or in the alternative, ordering him to complete some kind of in-jail program and releasing him when he completes that. He did miss his sentencing dates, and he does admit that he was wrong for that. When we talked about that, he reported to me that he missed one sentencing date, filled out the warrant recall, and it was the same day it was reset. And due to technical issues, he missed the additional sentencing date. At that time, I mean, frankly, our conversation went, why would I miss the date when the original sentence was just a fines and costs recommendation? He didn't miss court intentionally to evade sentencing. I mean, frankly, that was a more beneficial sentence to him than he's facing today as the recommendation goes. He understands he needs to be here in court, and admits that he messed up, but wants the court to take all that context into consideration. Further, he is suffering with some health issues, including some issues in his brain. He would like to get out and address those. He needs further testing that is unable to be done in the jail. He did complete an addiction program while in prison. He's been clean since he completed that program. And it is on Suboxone and doing well. He reports to me that he takes care of his elderly parents, as well as his wife, his two stepchildren, and his child. They all live with him, and he wants to get out and get back working. He runs his two own businesses. He's a mechanic and a house remodeler. He says that he doesn't even have a license, but he essentially made a business in his backyard so he could keep working and take care of his family, because he can't drive to work. So he brought his work to him. I mean, this case, Your Honor, is about $123 worth of stuff from Walmart. He's agreed to pay restitution and make Walmart whole. I'd ask that the court not sentence him to the full 365 and consider some other resolution that includes that restitution. He does have another pending case that he vehemently denies and wants to work with his attorneys on the outside.
Ms.
Clear
Blair.
on behalf of probation. Your Honor, it is correct that probation's initial recommendation to the court, given that he completed programming while in MDOC, was a fines and costs only sentence. However, Mr. Atkins failed to appear for sentencing before this court not only once but twice. And then when reviewing this, once he was picked up and has been at the jail, has picked up a new felony, which also involves theft of some nature. He may deny that. However, his criminal history has several retail fraud offenses. So he's demonstrating to the court, one, that he doesn't comply with what the court's telling him to do. He doesn't even come here when the court asks him or orders him to do so. And does the bench warrant recall, gets reset, bench warrant recall gets reset for court, and then doesn't appear. And I believe the reason he's before the court today is because he's in custody.
Mr. Atkins, anything you want to say before I impose sentence?
Sure, yeah. I missed the court here because the charge that I'm in here for, the cops took my phones. So I've got a lot of stuff. I got myself into something that I didn't know that I got myself into, basically. Had no recollection of it. Or not recollection, that's the wrong word for it. Didn't know who I was keeping myself around.
You don't want to get too
So,
much.
right, I'm just, he knows. I'm telling
Oh,
you
yeah.
straight like I
Well,
always
I
have.
know
always
what
will.
it's about.
I've never lied to you. I've always been straight up with you. And like, I just need to be out there so I can get better rep, so I can fight my case out there, because what they're trying to do is none of the facts. And I don't know really what all of it's about, because you can't get the information you need while you're locked up in here. But with my wife's help that's sitting back there, that's got my back 100. My family got my back 100. Like I missed court solely because I got so much more going on. And I didn't mean that it's not serious, because it was serious. But the day that I missed court, I was up here, tried to get it taken care of. You had already left the same day when I did the recall. And then when the cops came and took my phones, like I've literally, my life got turned upside down in hours, and I didn't know that any of this was going on. So I'm not making an excuse. That's just why I missed court. I don't make a game on missing court. Like, it's serious. And that's all I got to say.
Part of the problem is, Ryan, and we've dealt with each other for a long time, you got 23 prior retail frauds.
When I was on drugs.
Well, you have 23 of them.
I get it.
And then you have this one coming up, this one here that I'm about to sentence you on. And I don't mind giving a break, but then while this is pending, a whole other issue comes up regarding potentially, and I'm not presuming you're guilty of it, but a theft of machinery. I mean, basically. Hold on. Because I don't want you to say anything about it because it's pending, but I'll just say this, that part of the problem with you is that it goes from, say, this one's $150 basically, up to now where there's accusations that amount to hundreds of thousands of dollars. Right? And you know, I'd like to ignore that. I've never had anything against you. I mean, I realize what you've been struggling with and dealing with, but I can't ignore that either.
And I don't ask you to. I just ask you to maybe look at, has that ever been my MO? Ever? And like, come on, I commit misdemeanors. You've dealt with me my whole life. Like, just to me, it just sounded like, how do you go from $150 to hundreds of thousands of dollars? Like that.
And that,
and
being maybe so, the $1 million question, right? I don't know.
And that's why I want to be out there so I can figure it out, because I myself is still figuring out what is, I mean, if you have a guy come do work for you and then all of a sudden he gets you pulled into something that you don't even know, that's where we're at with that. Like, and
maybe that's how it's going to turn out. Hey, and I'm not here to argue and debate that case,
right?
But that's one thing. The other thing is, and you know how I am, Ryan,
I do.
I just ask you to do certain things and you just have to do them. And if you do them,
always been
you're
good.
okay
Right.
with me. But if you don't, then you got a problem.
And I was
And
doing
just
them.
remember in this case, Ryan, you didn't you didn't do your first PSI. And don't tell me you don't know how
I
it
don't
works
have an
here.
excuse for that.
Ryan, I'm not gonna sit up here and try to overtalk you. I'm just telling you that. And then next thing you know, you don't show up, issue a warrant, allow it to be recalled, and then you don't show up again. And I couldn't even be guaranteed that you were gonna show up today necessarily, or whenever we got you back, except that you got caught up in this other case. So the sentence of the court, $125 statutory fee, $149.66 restitution to Walmart, payable to the court, which will be due 30 days after release. I am going to send you to 365 days in jail, credit 18. You are to serve that balance. I will consider and take into account if that other matter is resolved, how it's resolved. I'll take a look at it in determining whether or not to adjust the sentence. But at this point, I'm not going to do that. All right. Thank you. Sir, come in. Courthouse case, People versus Eric Harris.
Yeah. Good afternoon. Eric Harris, yeah.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Harris. Your Honor, today's the same time several sentencing. We have reviewed the pre-sentence report. We don't have any material changes, additions, or deletions. We ask that you adopt the sentence recommendation.
Mr. Harris, anything you'd like to say before I impose sentence?
No, sir, Your Honor.
Sentence of the court, I'll place you on 24 months probation. You are to pay $655 fines and court costs, $720 probation oversight fees, and $145 restitution to Kahandakar Rashid, payable through the court. Now, is he locked up on something else?
Your Honor, I believe that he does have another pending case out of the 1482 District Court. He goes for sentencing in that matter December.
Sometime in December.
Yes, Your Honor, it's December 17th. So I believe he is being held with 25,000 cash surety fund on that matter.
I do believe there is a release of treatment on that case, though.
There is.
Okay, well, he won't be held on this one. I'll just make that payable 60 days after release.
What do you say?
I would indicate to you that, you might want to touch base with probation upon your release to try to work something out regarding the payment. There's to be no use of alcohol, recreational marijuana, or any substance. You'll be subject to random testing as requested by probation. You are to complete an inpatient substance abuse treatment program, including and follow all recommendations, including any aftercare with status reports to probation. There is to be no assaultive, threatening, or intimidating behavior. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to begin and maintain employment with verification to probation. I'll order 365 days in jail, credit 56. Serve. Defendant to remain in custody until direct release to inpatient treatment, and then the balance of your sentence will be suspended. Okay, so that would be consistent with the other.
Your Honor, what was that, $1,300?
You want me to do math? Oh. Let's see, 655, 720, and 145. How much? 1520.
Okay.
I did that math myself.
Yeah, I see.
Yeah, all right. Okay. Thank you, sir.
Okay.
I got them, but I can't get them out.
Is that all you guys have?
They have one more too.
Oh.
Okay,
Yeah,
I'll do that, but that's everything,
okay,
okay?
thank you. Did you look at body cam? I mean, the footage from there?
Yes, it's all here.
Sure.
Yes. I promise, I promise.
All right. Okay.
Oh, that was so sweet. What was all that about? How are you?
No, but talking is my favorite part. I love.
So do you want to make?
Stories. Yeah.
All rise. The 14A District Court of the County of Washington, State of Michigan is now in session. All those having business for the court draw near. Honorable Judge J.
You may be seated.
Okay, guys, just a quick pause to let you know that we've crossed days. That has ended the Monday, and now we've moved into the Tuesday docket. The rest of the show from here on out will be the Tuesday docket. The very end of the show, the last 30 or so minutes of the show, is a pretty popular case that has been making the rounds. Just throwing that out there. I put it in here because I haven't seen it yet, and I wanted to see it. Ladies and gentlemen, the judge has a special announcement right here and a special guest to introduce to everybody. Let's check it out, shall we?
Okay. And, it's good to see you, Mr. Ganatra. Before we begin, I have the great pleasure of having beside me one of our newest elected judges, Judge-elect Corrine Moore. She will be sitting with me today until she can't stand it anymore, and then she's taken off. All right, so welcome, Judge Moore. Mr. Ganatra, can you start us off?
Good morning, Your Honor. My name is Ganatra, Senior Assistant Prosecuting Attorney on behalf of the people. Conflict between this honorable court and the Office of the Public Defender. Prosecutor's Office does not believe the conflict exists. When present, we waive that qualification. My office, the Office of the Public Defender, before this honorable court.
Thank you, sir. And here we go. Mr. Brown.
Morning, Your Honor. Juan Brown, Deputy Chief Public Defender. We likewise do not believe that a conflict exists in this honorable court hearing this. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Court, for its part, also does not believe that a conflict exists either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People State of Michigan versus Alejandro Montano.
Name is Ganatra for the people. Ms. Cratcher's case.
This is the motion. Hamoud's withdrawn. Why is she doing that? Let's see.
Good morning, Your Honor. Marcia Cratcher on behalf of Mr. Montano.
What are you going to do if I deny Ms. Hamoud's motion?
I'll be in big trouble.
Oh, okay. All right. I'll grant her motion to withdraw. Go ahead, Counsel.
Good morning, Your Honor. Marcia Cratcher on Mr. Montano. We'll be seeking an adjournment in this matter. He's in federal custody, I believe, at the moment.
All right. Mr. Montano, can you state your name, please, sir?
Yeah, my name's Alejandro Montano.
Thank you, sir. All right. You understand that your prior counsel is withdrawing and you have new counsel. You understand that, sir?
Honestly, I don't even know what's going on.
If I may, Your Honor?
Only if you're going to clarify it.
I am.
All right, go ahead.
Okay. Your Honor, I was just appointed on this case, I believe, yesterday. And therefore, Mr. Montano is in federal detention. And I have sent a request to set up a meeting with him. I believe you're in Hazleton. Is that in Minnesota, sir?
No, that's in West Virginia.
West Virginia. Okay.
Close.
It's been open
maybe
a year
So-
and something. I don't know what's going on with this. I don't know why y'all keep pushing
So,
it.
sir-
I don't know what y'all got going on.
Okay, hold on a moment, sir.
So, Mr. Montano, I will contact the facility that you're in and make an appointment to come and not see you, but at least have phone contact with you, and I can explain that, sir.
See, that's what the last attorney said a month and a half ago.
I can't speak for the last attorney. I can only speak with what I'm going to do. I actually
I'm
was
saying
in
though,
search-
why would you come and try to talk to me the day before court or a day before court? You need to talk to me like as soon as possible, not whenever you feel like that, y'all. I don't know what y'all got going on.
Okay, Mr. Montano. So I don't know anything about them trying to talk to you. I'm going to give enough time that they'll be able to try to contact you and to be able to talk to you before we get to the next hearing. The
Look,
other
the thing
thing
is, I've been in custody
Sir?
since May 3rd.
I know.
23.
Okay, you
This
done?
case is from May 3rd,
I'll let you
23.
go. What? Okay, so here's what I'm gonna do. What is 6 weeks out?
January 9th.
All right. What I'm gonna do, sir, is I'm gonna adjourn your probable cause to January 9th, 2025, 9 a.m. Ms. Crater will be in touch with you, and hopefully we can move this case along. All right? Thank you.
Thank you, Your Honor.
This shit is crazy, man.
Gotta mute that, because we got exactly one case done. All right, what? Court calls the case, People versus Ryan Piper.
Morning, Your Honor. Attorney about the people.
Ready in that matter. One Brown, Deputy Public Defender, appearing with and on behalf of Piper. Mr. Piper, could you state your name for the record?
Can't get to the. Okay, Beaver, he said his name.
All right, thank you, Honor. Today is a date and time set for a competency. As the court may be aware, my client has been found incompetent but restorable.
Correct. We were waiting on an amended report.
We have not received that at this time.
Have the people received any? All right, what I will do is, do we have any news as to when that might be coming, or, all right, I'll give time for you guys to check. And let me just adjourn the competency hearing out to December 26th,
okay,
2024 at 9 a.m.
Thank you.
Bond will continue. Thank you, sir. Court calls the case, People versus Leroy Federico.
Morning, Rob J. Cole on behalf of Mr. Federico. Leroy, would you state your name for the record?
Yes, Leroy Federico.
Judge, I met this young man. We've had a couple conferences. He'd like to set this exam. If possible, although, Your Honor, I have trials on the 19th. I would ask the court if it could accommodate after that.
Right, hang on. The date I'm working off of is wrong. 12. Next one's the 10th. Got it. Is all discovery complete, Mr. Killaway?
Yes, Your Honor.
Would the people have their, you can't do the 10th is what you're telling me?
Could we,
I didn't ask that.
No.
Can you not do the
No,
10th?
I cannot do that.
Will the people have their witnesses available the 17th?
I believe so.
Preliminary examination in person will be set December 17th, 2024, 9 a.m. That is for Judge Bravo. Bond will continue. Thank you.
Thank you, Your Honor. I'll come and see you.
So what we setting is what we all probably works. So
She switched it.
she got. Oh, really? Oh.
Did you schedule that for me?
So we'll get okay. Court calls the case, people versus John Cahill.
Your Honor, good morning. Joe Simon on behalf of Mr. Cahill. Mr. Cahill, will you please state your name? Your Honor, I see his lips moving, but I don't think we. Speak up if you can, Mr. Cahill.
He's muted. Whoever is assisting, if they can unmute you, thank you. Mr. Cahill, can you state your name?
John.
Thank you. All right, what are we doing?
Your Honor, the last time that we were here, Mr. Cahill had moved from his skilled nursing facility to the hospital. His situation was not great, but he's now out of the hospital and back to the care facility. I spoke with Mr. Ganatra, and he is going to inquire with the officers about a potential resolution asking to adjourn the PCC.
All right, how much time do you need to get that accomplished?
Mr. Ganatra?
I'd ask for at least 2 weeks, sir.
Okay. We're gonna go to December 19th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Mr. Cahill. Court does call the case People versus Daryl Hicks. Durrell.
Good morning, Your Honor. Marcia Cratchit on behalf of Mr. Hicks, who's approaching. Mr. Hicks, can you please state your name?
Hicks. Thank you.
Your Honor, we would be asking for a preliminary exam of this matter. Discovery is, my knowledge, complete. According to, I'm sorry, sir.
You were not done talking. Go ahead.
I would believe we're requesting a half a day exam, so I don't know if the court would want to put on a special day or on a Tuesday.
People have their witnesses available on the 10th? Should. What I will do in this instance, I'll set preliminary examination in person, December 10th, 2024, 9 a.m. before Judge Burke. What I would suggest that you do, if you think that it's going to interfere with that schedule, contact Judge Burke's office and see when he can give you a half day.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Hanzo.
Your Honor, Joe Simon on behalf of Mr. Joe. Mr. Joe, state your name. Joe.
All right. You're requesting an adjournment for immigration issues.
That's correct, Your Honor. And Your Honor, Ms. Barroso tells me that we should probably request at least a month for that.
I think that.
Why did she tell you that?
It has to
Not
go.
Barroso either.
Oh, my goodness, I did
know
do
you-
that. I fumbled.
You should.
I'm sorry, Ms.
You need to
Bassan.
apologize.
I do apologize. Ms. Bassan. I know better too. Sorry.
I don't, and I'm still getting used to it, and that's how I knew who you were talking about, but it's pretty bad.
In any event, there's a protocol that I understand needs to be followed that would require that amount of time.
Probable cause conference, December 26th, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Ryan Atkins. Whenever you see them,
Andrew Children's attorney on behalf of the people.
regardless of whether they're
When Your Honor, Assistant Public Defender Carson Mulvey on behalf of Mr. Ryan Atkins, who is present to my right. Mr. Atkins, could you go ahead and state your full name for the record?
Pardon? Go ahead.
Good to see you, Your Honor. Your Honor, at this time.
Long time no see. Where are they? Where?
14A2, they got me over there.
Oh, okay. All right.
In the cave over there. And see.
Whatever you want to call it. Go ahead.
Your Honor, at this time, we respectfully request you to set this for an exam.
All discovery is complete.
To my knowledge, yes.
Will the people have their witnesses available 10th?
That's fine, Your Honor.
All right. Preliminary examination in person will be set December 10th, 2024, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you. Bond will continue. Hey, Mr. Bubasi, Mr. Atkins probably let you know, I'm holding him on another matter.
Yes.
So that once that resolves, somebody should contact my court to let us know. Thank you. Court does call the case. People versus Matthew Menke.
Ready, Your Honor.
It's Poison.
Your Honor, Joe Simon on behalf of Mr. Menke. Mr. Menke, can you state your name if you're unmuted?
Matthew Menke.
All right.
And Your Honor, Ms. Poisson and I have accomplished a great many things, including a resolution of the case. You should have a plea sheet. Mr. Menke was not able to, since he is in a treatment facility, was not able to return an advice of rights executed and a sentencing judge waiver, but I got him both of those forms and discussed them with him. He's ready to enter his plea accordingly.
The plea form indicates that the defendant would be pleading to count 4. He's pleading as to the charged count 4, domestic violence, second offense, as well as to count 5, police officer resisting an attempt or attempted resisting and obstructing a police officer, both 1-year offenses. Upon this successful plea to that, charge counts 1, 2, and 3 would be dismissed. That's the court's full understanding of the agreement.
There's one other aspect.
Parties are agreeing to no upfront jail. However, this court cannot bind the sentencing judge.
Correct. And my client understands that, but that is a killer group between the parties. Yes.
Sir, will you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
State your name again for the record, please.
Matthew Menke.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes, Your Honor.
The first is the stated count 4 of domestic violence, second offense. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, I do.
The other charge is the charge of attempted resisting and obstructing a police officer. That is also a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, I do.
All right. Sir, you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. Do you understand that?
Yes.
Do you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of domestic violence, second offense, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
So you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Although you've gone over an advice of rights form, you understand that by not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, sir?
Yes, I do.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of these offenses?
Yes.
October 12th, 2024, at the location of 9359 Harbor Cove, apartment 254. What did you do on that date involving a Bailey Vanderweel that makes you think that you're guilty of this offense?
We were in multiple arguments, and I know I ended up.
Let's say what you did, please.
Okay, I was mad at her and her boyfriend, and I just made some threats, and then I ended up shoving her.
Okay, so you pushed her without her permission?
Correct.
And you did that purposely?
Purposely. I was drunk, but yes.
Although having had some intoxicants, did you know what you were doing at that moment?
I do remember some of it, and I feel like.
Mr. Menke, as we discussed yesterday, you have to be unequivocal. You intended to push her without her consent. Is that correct?
Yes.
And I think more importantly, at the time that you did that, you knew what you were doing.
Yes.
Who is this individual to you?
She was my girlfriend, and then probably like a month to 2 months before we agreed on a breakup, but we were still living together.
So, okay, so she was in your household, you were in a relationship prior to the breakup.
Yeah, that's correct.
Okay. Had you previously been convicted of a domestic on or about July 19, 2021?
Yes.
Yes? Okay. Did you come into contact with police officers on that day?
Yes, I did.
And what happened when you came into contact with officers?
I didn't let them in for about 5 minutes into the apartment, and then I finally let them in, and then I just didn't follow commands going down right away.
Okay. And you knew they were police officers?
Yes, I did.
And you knew they were in the lawful performance of their duties?
Yes.
Okay. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this case will be
At 9:30 before Judge Fresh Hour.
December 5th, 2024, 9:30 before Judge Fresh Hour.
Your Honor, regarding bond, the people and I have come to some agreements. We hope the court will also adopt. My client's insurance goes week to week for his inpatient treatment. We fully expect that to expire at the end of this week. And the date is uncertain, but it will be Friday or Saturday. Because of the parties' plea and sentence agreement, the people and I have agreed to the following, if the court will adopt, that he be allowed to have a personal recognizance bond, keeping his GPS tether with the 1 mile exclusion zone of the exclusion zone of 1 mile radius around the complainant's witness apartment, the same address that you just read is where she resides. And I can give a firm address where my client will reside in Brighton, Michigan with his father.
So it'll be a PR with a GPS tether with an exclusion zone.
Yes, he already has the tether presently to make sure he's where he's supposed to be at the treatment facility. But he will keep it and then.
So since we're changing the order, prepare a written order for the court.
Will do.
On that, and that way we can then do the community corrections order so that will happen.
Thank you, Your Honor.
All right, you need to get that in by the end of the day because Ann says she's leaving.
Do you want me to make this?
And I'm not allowed to do things by myself. All right.
Thank you, Your Honor.
In all other respects, bond will continue.
Thank you, Your Honor.
Thank you.
Thanks, Your Honor.
Court does call the case, People versus Jamison Boone.
Assistant Public Defender Jay Bellinger on behalf of Mr. Boone on both matters, Your Honor. Mr. Boone is. Can you please state your name for the record?
Jameson.
Thank you. Your Honor, after review of the files, it's my understanding that discovery is complete. We would ask to set for preliminary examinations this time.
On both cases, say correct.
Yes, Your Honor.
People have their witnesses available the 10th. And go.
Do our best.
Preliminary examination will be set in person December 10th, 2024, 9 a.m. before Judge Burke.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case, People versus Jillian Carey.
Richard is appearing on behalf of.
Good morning, Your Honor. Michael Bavana on behalf of Jillian Carey, present to my right.
Your name, ma'am?
Jillian Carey.
All right. What are we doing on this?
Your Honor, we're going to be setting this for a preliminary examination.
I think we were looking and speaking with Mr. We're still hopeful that there may be an additional report from Detective Parvez, but we're fine with setting this if we could set this into January if possible.
You would agree with that, counsel?
Yes, Your Honor, the weeks of January 20th particularly.
Well, you don't get to pick a week.
Or the 13th.
And all discovery is complete, is that correct, counsel?
Other than perhaps that report, yes.
With the exception of the materials that I requested and was denied, yes.
I don't know what that means.
Your Honor, you denied a motion to compel discovery last time. That is the material I'm talking about that I've not received and the court has not examined. So that will be the discovery that I'm talking about. But I'll pursue that at a different level. Your Honor has already denied my motion, so.
I still don't know what that means. Do you have all of the discovery, counsel?
I have all the discovery that they've given me, yes.
And if I denied your motion, that would mean that would be something that you're not entitled.
That's the court's position. I don't agree with the court's position. And so I can't answer that question that I've gotten all the discovery.
All right, then I'm not setting it for exam until we're sure that discovery is complete. That's how we work here, counsel. So you guys figure it out. Is from the people's perspective, has discovery been completed other than the one thing you've indicated?
All right. Well, since we were last year in court, Detective Parvez did offer what I would call a supplemental report that has been tendered via email about 2 weeks ago. I also discovered there had been some body cams that hadn't been properly notified, like notice had been sent to my office. Those have also been tendered. So as far as from what is in possession of the people, everything has been turned over. The only remaining discovery that may exist that I'm aware of would be this additional supplemental report by the detective, but that investigation is ongoing.
So I'm going to try this again, counsel. You have all of that. You may disagree with this court's decision, and I could care less, quite frankly. If you want to appeal it, appeal it. The question is, in terms of what should be supplied to you, do you have everything?
I have everything that was described by the prosecutor, Your Honor. So yes.
The people would have their witnesses available January 21st, 2025.
I don't see any reason why not.
Preliminary examination in person, January 21st, is it?
Yeah.
2025, 9 a.m. That's before me. And counsel, if you want to keep playing these wordsmith games, I'll go toe to toe.
Your Honor, I'm just.
Thank you. Bond will continue. We're done.
Okay.
You want to address it, Commissioner Bond?
Oh, I'm sorry. There's one more matter, Judge, to address. My client is currently restricted to travel in the state of Michigan. Her family is located in Toledo, Ohio. I would ask if she be allowed to travel over the holidays.
Prepare an order, get it to the court today. I'll sign off on it.
Thank you, Judge.
Thank you. Emily will talk. You're not talking to me. I got some things to say. Just let you know. Court does call the case People versus David House. You know that. You know they're gonna come out.
Good morning, I'm People on behalf of David Outwood.
That's his motion.
David, would you state your name for the record, please? David Paul Ousley. I was just appointed, I'm sorry. I was just appointed on this matter, but there needs to be some further discussions between my client and the prosecutor. We're asking for please.
Any objection from the people?
Just for the record, we do have a protective order that Your Honor just signed today, I believe.
Yes, I have signed off on a protective order. Probable cause conference. Mr. Killowald, were you not available the week of the 9th? Is
that's correct.
Calling.
That's correct.
So we could do, so I'll adjourn it out to December 19th, 2024, 9 a.m. Bond continue.
Zooms it. Thank you, Judge.
Your Honor. You're welcome, sir. Court does call the case of the People versus Melissa Milliken, I guess would be it.
Good morning, Your Honor. Good morning, Judge Blackmore. Nicholas Rumel on behalf of Ms. Milliken. We would like to set this for an exam and with the People's and Your Honor's permission in January sometime.
Everybody's picking their dates. Is your client here?
She is. She's ill, but can you come up to the podium? I thought she was behind me. Yeah.
Your name, ma'am?
Melissa Milliken.
All right. And all discovery is complete, Mr. Mermel?
It is, Your Honor.
People have their, you want a date in January? Why does everybody want January? What's my first date in January? Or a first date in January? Would you be ready on January 2nd?
I believe so, but just give me one moment, Your Honor. Yes.
Yes?
Yes.
Said, okay. People have their witnesses available the 2nd?
Yes, Your Honor. Thank you.
All right. Preliminary examination in person, January 2nd, 2024, 25, excuse me. 9 a.m. That is before Judge Barr. Bond will continue. Thank you.
Thank you very much, Your Honor.
All right. Have a good holiday, sir. Court does call the case People versus Terry Lanier. Good watching. Good. So you're gonna do this one?
No.
No. This is attorney. Carson, state your appearance, please.
Good morning, Your Honor. Attorney Stephanie Carson on behalf of Terry Lanier.
Your name, sir?
Terry Lanier.
All right, what are we doing?
Your Honor, I'm asking to adjourn the PCC. I do not have discovery yet.
Your Honor, I just found that there were 274 pieces of media on evidence.com last night that had not been shared. I went through the request of having those added to the discovery packet this morning. They should be released to Carson today.
And shall we have to go through those in a day? No, I'm great. All right. All right. Here's what I'll do. Probable cause conference, December 19th, 2024, 9 a.m. Bond continue.
Thank you.
That's how. Thank you. Court calls the case, People versus Rita, is it Atik?
Andrew Childers appearing on behalf of the people.
They're on Zoom. You're not sure what? Mr. Tramontaine, are you there?
We are here, Your Honor. For some reason, my camera is not operating. I'm using a different device. I apologize.
All right. I recognize your voice. I'm sure it's you. Your client is with you?
She is.
All right. And upon the representation by you, I'll take that. What are we doing on this case?
Your Honor, this is a time and date set for probable cause conference. At this time, we are requesting a preliminary examination, and discovery is completed for exam purposes.
Thank you. And would the people have their witnesses available on the 10th?
That's fine, Your Honor.
Preliminary examination in person will be
Your
set.
Honor, excuse me. I do have.
I knew it, Tramontaine. I knew it. First of all, I can't see you, and now you're going to cause problems with my dates. Go ahead.
We were going so well, but just a slight modification on the date. Could we have the 17th if that's available? I have a conflict on the 10th.
Fine. December 17th, people's witnesses will be available that date also.
That's awesome.
December 17th, 2024, 9 a.m. I knew he was going to cause problems. Before Judge Washington.
Thank you very much.
Thank you. Have a good holiday, Mr. Tramontaine.
Likewise. Thanks.
Calls case, People versus Ariane Browning.
What's on for the people?
This is Public Defender Jay Bellinger on behalf of Mr. Browning, who approaches. Mr. Browning, can you please state your name for the record?
Ariane Browning. Thank you, sir. What are we doing?
Your Honor, we are asking to set for preliminary examinations. My understanding that the remainder of the discovery was sent over last night.
All right. So you have all of the discovery?
That is my understanding.
People have their witnesses available on the 10th. Preliminary examination in person, December 10th, 2024, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus David Phillips.
Morning, Your Honor.
Just stop.
Good morning, Rob. Well, Judge, I believe there's two matters.
There is.
I'm 24 FB 1400.
For our Assistant Public Defender, Constable Basie, on behalf of Mr. Phillips on the other matter. Mr. Phillips, could you state your full name for the record?
David Phillips. Thank you.
Mr. Phillips is requesting that these matters have a preliminary exam.
Is that correct for you also?
Correct, Your Honor.
All discovery is complete on both matters?
Yes, Your Honor.
Do people have their witnesses available on the 10th?
Judge.
You can't do the 10th. I know.
Do it the following week.
People have their witnesses available the 17th?
We should also be able to do that.
Yeah. Preliminary examination in person will be set December 17th, 2024, 9 a.m. before Judge Balvo.
Just so you're good.
No. Bond continued.
Thanks, Judge.
You don't have to do it exactly. Is that really just gonna sit here and not work? No way. No way. We're like Home Depot. This is what? You want to go to Judge Washington? See? She wants to go over there because I said we're like Home Depot. This is a working warehouse up here. So you just got me. But now I'm hurt. You know how I get when I'm hurt. Court calls the case, People versus Joshua Quick.
Good morning, Your Honor. Assistant Prosecuting Attorney.
Morning, Judge. And soon to be Judge Mike Gaddy, Assistant Public Defender, on behalf of Mr. Quick, who's here to my right. State your name, Mr. Quick.
Joshua Ryan Quick.
I was assumed to be judge.
No, she's a
What?
soon to be judge. You're
Oh,
judge.
okay. I just didn't know. I didn't know if you knew something. I did. No, go on. Your name, sir?
Morning, Joshua Ryan Quick.
Thank you.
Your Honor, we'd ask the court to set this for an exam.
Discovery is complete.
To my understanding, yes, Judge.
And bless you. Would the people have their witnesses available on the 10th?
Yes, Your Honor.
Preliminary examination in person, December 10th, 2024, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Oh, one last. Well, hold on. What happened? What'd you do?
Wait, I thought I was covered.
Yes, it is. And that, no, that's, I'm sorry. No.
Do you, is that for 2 copies or no one else?
No, because I got 2 different. I have 2 cases, and so each case, got it?
Yeah.
Yeah. He likes me. Court does call the case. People versus Amanda Smith.
For the people.
Amanda Smith.
I apologize, Judge.
Morning, Rob Chico on behalf of men.
Your name, ma'am?
Amanda Smith.
Thank you.
Judge, I've had some negotiations with Mr. Ganacho. We're asking to set this out, the PCC. Hopefully we can resolve it at the next hearing.
Probable cause conference will be adjourned without objection, December 19th, 2024, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor. Have a wonderful Thanksgiving.
You do the same. Court calls the case of the people versus Kyle Rainey.
Nicholas Sinatra for the people.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Rainey, Your Honor. State your name.
Kyle Rainey.
Your Honor, we'd ask the court, I believe Ms. Iconrulli submitted a green sheet. We'd ask the court to adjourn this matter.
For mitigation information, is that coming through the office in your office, or is this some other form of mitigation? How much time do you need?
Yeah, I would ask for 2 weeks. 3 weeks. 6 weeks, $1.
Why don't I do this? Let me adjourn it out to the 19th. And then you can see where you are. I don't want to put it too far out because he's in custody, so. December 19th, 2024, 9 a.m. Bond continue.
Thank you.
Thank you, Ed. Yes. Court calls case of the people versus George.
Your Honor, I'm sorry, I'd ask the court to respond in this matter.
Go ahead.
I was arguing incarcerated. I didn't work 8 hours. Came and picked me up from here, and then I came from Hillsdale here.
Your Honor, I'd ask the court to consider a personal recognizance bond for Mr. Rainey. I believe he had a failure to appear, but it appears he was in custody in Hillsdale County at the time and then brought here.
On what?
On this matter, I believe.
I got Hillsdale.
Yeah, but why was he in custody?
Oh, sorry.
So he was in custody in Hillsdale on a CCW. Did that occur while he was on bond on this case?
No, Your Honor, I believe it was.
So he started allegedly using meth after.
The date of offense for the CCW case out of Hillsdale is 3/26/24. Date of offense on this incident with you is 6/6/24.
Is he in custody in Hillsdale?
6 months.
I believe he's finished that matter, Judge.
Well, that isn't, but that's not making much sense. So he was in custody at the time of this hearing?
I believe, yes, I believe there was a failure to appear.
Why were you put into custody on the CCW out of Hillsdale?
They
Because you didn't appear?
No, they just, when they picked me up, they ended up bringing up the charges. They arrested me on it, but didn't arrest me on it. And then later on, they brought the terms up later on when I ended up coming in for you guys.
Because you violated your bond on that case by picking up this case.
No. They had a hold on me. That ended up the state police picked it up. Like when the occurrence happened, they let me go. And then about later, a couple months later, then they finally picked it up. The state did.
Are you talking about in March?
Yeah, this has been like the beginning of the year when it actually happened. When actually I was pulled over for the traffic stop.
And you pick up a CCW charge out of that?
Yep.
You're let go?
Yes, they let me go at the time. And then once I get pulled over here, that's when I realized that they brought up the charges. Then that's what got me initially stopped for here.
So you had a warrant out for you when you got stopped here?
Yes.
Yeah, it was a felony warrant. I assume they don't usually send notices on those. I assume they charged him. He then got this case, and this is involves labs.
Get you.
Yeah. This matter involved labs, so I imagine there was no immediate charge.
And so what happened with the CCW?
I got 6 months and 2 years probation.
So you were incarcerated for 6 months on the CCW?
Yes. And then I got brought here.
I'm going to need some more information on that. I'm not going to let him go. The bond will continue on this matter.
Thank you.
Court calls case People State of Michigan versus Shaquille Tubbs.
Michigan Oscar for the people.
Assistant Public Defender Tella on behalf of Mr. Shaquille Tubbs, who is approaching the honor.
Your name, sir?
Shaquille on the up top.
Is that all of his name? No, that's not all of his name, but that's okay. That's okay.
She usually say half of it.
Yeah. Okay. All right, what are we doing on his case?
Yes. Your Honor, today's the date and time set for probable cause conference. There's a bit of outstanding discovery. So just
a bit like what?
A video, Judge. I believe there's just a video that we haven't quite received yet. I think we can get that resolved by our next probable cause conference date. So I would ask for an adjournment respectfully.
Probable cause conference, you want the 5th or the 12th?
I'm sorry, Your Honor.
The 5th or the 12th?
The 5th should be sufficient, Your Honor, please.
Probable cause conference, December 5th, 2024, 9 a.m. Bond continued.
And Your Honor, if we could please address bond briefly.
I just did, but go ahead.
Okay. Your Honor, if we could please request a GPS tether for my client. He would like to address his mental health needs. You were going to speak with.
I was going through Harbor Oaks in New Baltimore, but another thing, this is what I was asking of you, Judge, because you know, me and you got history, and it's always the same thing. I'm always locked up, high bond, no bond. You did this one time for me, and if you know what happened, I was in by the same night. I look at it as not much of a risk for you, but something to show that because it's tether bond, it's GPS. You gotta mess up. I'm right here in the morning, right here for you. But my thing is, I was trying to more so see if I could, you know, get these things together myself, man. This time, you know, I can't fail you. You know, just try it out.
Response from the people.
Your Honor, on both files, the felonious assault and the destruction of property, I know that the people provided bond information forms. I'll add to that.
Good.
There's concerns for her taking care of himself and
Yeah.
public safety. That's why I'd asked for the court to deny it.
Is there going to be mitigation information sort of provided? Well, Mr. Tubbs, you were in treatment or trying to go?
Yes, I was in treatment. I was supposed to, I got things that I gotta follow up on, like shots that I can't do in here. I gotta, I'm actually supposed to go back to New Baltimore and things.
When were you supposed to go back up there?
I was supposed to go, I think the 2nd of this month. And I gotta do it again next month on the 2nd, every month. On the 2nd.
So what happened on the 2nd for you when you go?
I get a shot, I go in treatment, they look and they
Gotcha.
see how I am, and they release me and they check back up with me, like in my file, they get me with mental health. And
Right.
Mental health right around, and that's what they do right now. Like they do observations on me. Basically.
Okay, I got you. So here's what I'm gonna do. I'm gonna deny the request for bond. I'm gonna keep his bond where it is. Certainly, counsel, between now and the December 2nd, even if it's by email or whatever, if we could provide to the court exactly what Mr. Tubbs is supposed to be doing, I'll consider a release. I'm not gonna say I will do it, but if you can provide to the court more information to structure what happens on the 2nd for Mr. Tubbs, what that whole program is about, and how we could monitor his follow-up in it. Okay?
Yes, Your Honor. Thank you.
You got that, Mr. Tubbs?
Yeah, now, as far as the we're adjourning.
I'll discuss it with you, Mr. Tubbs.
But my court date is
It's going to be December 5th. All right, we're going to talk.
All right. Take care, Mr. Tubbs. Court calls case, People versus Robert Lawson.
Morning, Your Honor.
Sorry, I'm sorry. Marie Canha for the people.
I apologize, Your Honor. Good morning. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Lawson, who's standing to my right. Sir, please state your name for the court, please. Your Honor, we're here. It's a second probable cause conference, so we're asking for an adjournment this time so that I can attempt a resolution of the case without the need of an exam.
December 12th, 2024. 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls case, People versus James Williamson.
Assistant Public Defender Otel on behalf of Mr. James Williamson, who stands to my right.
Your name?
James Williamson.
Thank you. What are we doing?
Your Honor, today's the date and time set for probable cause conference. We're asking for an adjournment for a proper reason, Judge. There may be a potential resolution at this level. Sister counsel is going to reach out to the complaining witness in this matter and see what we can do on that.
So you don't do green sheets?
I do. I'm sorry, Your Honor.
Don't.
I haven't been
like
at
the second one. I let it slide the first time. I don't know why.
Thank you.
Wow, just called him out.
I haven't been at PCC since their institution, but I'm going to draft them both up and knock them out for you, Judge.
Thank you.
Thank you.
So you need an adjournment on this? How much time will it take you to have that conversation and then come back? I can, 2 weeks? Probable cause conference will be December 12th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Theodore Stewart.
Ready, Your Honor.
Good morning, slowing down, Your Honor.
No, it's okay.
And good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court. Edward Martell, P 85051, on behalf of Theodore Stewart, who stands to my right. Sir, please state your full name for the record.
Theodore Jonathan Stewart. Thank you.
Judge, if I may?
Yes, sir.
Thank you. Today's date and time for probable cause conference. We are in receipt of some discovery. Judge, we are still seeking additional discovery. My client's been fully advised of his right to an examination within 21 days. He understands and appreciates we're not waiving the examination. We're seeking to waive the 21 days, Judge. And that is saying we're humbly asking to adjourn the probable cause conference.
No objection to the adjournment, Your Honor. And counsel, have you contacted our office for the discovery? You have it. Where are your spots? I want to make sure you get it.
So we do have limited discovery. There is some additional discovery, namely medical records, and my staff is working to procure that now.
Okay.
And these are medical records that would need to be obtained from a hospital?
Well, Judge, I cannot state for certain whether it's from the hospital or the people, but it's certainly pertaining or related to the underlying allegation.
All right, here's what I'll do. I'll adjourn the probable cause to December 19th in case they have to come from a hospital, so we can make sure that that can get to the people and then over to you.
Thank you, Judge.
December 19th, 2024, 9 a.m. Bond continue.
Thank you, Judge. Always a
And
pleasure.
if you may, I'm sorry, I just want to make
Sure.
sure. Have you made the request with our office for what you're seeking?
The original request was made upon review. Just yesterday, I realized that we do need some additional, so it will be made immediately.
Okay, I just want to make sure we're covering our end of things. Thank you.
Thank you.
Thank you, Judge.
Thank you. We didn't, this one was initially, but of course, yes. We got it. Court does call the case, People, State of Michigan versus Darren Wilson.
And good afternoon, Your Honor. Good afternoon to your fine staff. May it please the most honorable court. Edward Martell, P 85051, on behalf of Darren Dwayne Wilson. Sir, please stand and give your full and complete name for the record. Darren Dwayne Wilson.
Thank you.
Your Honor, today is the date and time scheduled for a preliminary exam. I believe that Mr. Martell would like to start us off by motioning for Your Honor to recuse himself from this case.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, the sole basis that the people intend to introduce quote unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that the counsel is attempting to.
Well, then I'll let him finish, because I don't know, it did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People v. Real, which is 391-124, Judge. It certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue because I think it's a. Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter, certainly
But
testified.
but that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your
Does
position.
that case clearly apply to search warrants?
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martell.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge, what I'm
just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they made a finding.
Judge, specifically, this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martell, that says under those circumstances, the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Burrell is applicable. And I would also humbly submit, Judge, the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion. So I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
All right. District Court for County of Washington State of Michigan is now back in session. The Honorable Judge Simpson preside.
You may be seated. Bring him back out. Court recalls case of the People versus Darren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. And please, this most honorable court, Edward Martell, P 85051, on behalf of Darren Dwayne Wilson. State your name once again for the record.
Have a seat. So, Mr. Martell, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, that case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding recusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may?
If it's not going to be a lie, go for it.
Judge, respectfully.
No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
you want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of the context. The main argument is what it is. And certainly Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear, I do have a lot to say about the law and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity. Facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that I'm choosing not, and maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case. It's from 1971. It's People v. Pitchford 3-3 Mish at 299, 1971. In that case, the defendant actually, at the preliminary exam, wanted to attack the search warrant that the judge approved. And that judge that had approved the search warrant at issue went on to be the preliminary examination judge. Mind you, on appeal, it wasn't that exact issue. It was more of a statutory interpretation issue that went up on appeal. But the Court of Appeals in that case said the statutory interpretation would have led to the same procedure, that the search warrant judge would have become the preliminary exam judge, and then they affirmed and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that Your Honor inappropriately approved the search warrant. And we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Just very
Martel?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recuse for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to misspeak this or in fact, when the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial, and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
but do
Judge.
not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26, 2024 at 12 noon.
Thank you, Judge.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I
That's-
am the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not of the people's doing, and the defendant, by raising it as well as before, has waived any time requirements. The preliminary examination as well as hearing on the motion will be January 2nd
Thank you, Your Honor.
at 12 noon. 12 noon. Thank you. Mine continue.
Wow. That happened. Well, kids, I don't have anything else. I'm still trying to wrap my brain around that guy. I've seen bits and pieces of that coming and going all week long. I haven't had time to sit down and watch the thing all the way through. And just wow. So we'll have to be looking forward to that next hearing. I'm gonna write that one down. Oh, Saturday, guys. Thanksgiving's over. We've all got to go back to work on Monday. Go do your stuff. Get your doings done. I'll see you again Monday night, probably. Most likely. We've got a new chief DA in Harris County. We'll have to see how it's going with Miss Kelsey Sigler, attorney at law. And one of our favorite judges, one of my favorite judges, Judge David Fleischer. We pick back up with the Fleischer Forum on December 2nd at 9 p.m. Eastern Time, 8 p.m. Central Time. And ladies and gentlemen, this has been the Weekend Case Review. We've had Simpson all day this Saturday. I feel like we have been missing out on a lot of other judges here coming and going, but that's mainly because of the holiday schedule. Stevens didn't have any court last week. Boyd didn't have any court last week. A lot of my favorite judges did not even have court last week. There was a good bit of stuff going on in Kansas, but I put out some isolated videos on that, so if you've missed that, check that out. And for now, ladies and gentlemen, I will be your lone wolf Usul. I'm your curator for the court gallery. I'm your humble host, the Weekend Case Review. And I will talk to you Monday evening. You guys have a great rest of your weekend. Love you.
Court does call the case.